bankruptcy isn't an option for cannabis businesses. But
Mhm.
I would love to hear your expert explanation of why that is and why receivership serves as an alternative.
It's actually very simple. Bankruptcy, as it's defined, it's a federal action, period. So if your company is illegal at the federal level that cannabis companies are, despite being legal in many states, you do not have a federal action of protection, which bankruptcy is, available to you. That's it. That's literally why bankruptcy is not an option. There's all kinds of variations if you use a Canadian holding company and this and that and the other, but fundamentally, you don't have access to the bankruptcy statute in the United States.
Got it. And so what you do have access to is
Receivership, assignment for benefit of creditors. There's other legal remedies available. The important thing to remember about a receivership is, because there's a lot of misunderstanding, because it is a bit of a black art. I'll give you that. There's no book on how to do it.
Hmm.
Is it's called an equitable remedy at law, which means the receiver is actually a neutral and doesn't work for either party, the moving party or the defendant, right? The plaintiff or the defendant. The receiver works solely for the judge. And that's kind of lost on a lot of people. We're not hired to be hitmen. We have to follow the rules as defined by the court in the appointment order. Does that make
So on
sense?
one side you have the company, and then on the other side, it's a major creditor, or is it a group of creditors? Is it all the creditors? How does that actually work?
Let's say you have a company that has loans to 3 different lenders and they've defaulted on 2 of the 3, right? Those 2 lenders are going to have standing to bring a receivership action to try to have a receiver appointed to protect what they deem are their assets. And then you get into the tug of war about whose collateral we're talking about, but all that should be defined in the loan agreements, right? The overarching goal of a receivership is to marshal and protect the assets of the entity, whatever is put in the receivership estate. And then you can sort of work forward some sort of remediation plan or adjudication plan. But again, the people that move for the receiver need to understand the receiver does not work for you.
Mm-hmm.
The receiver works solely for the court. And that hasn't been clear in a lot of appointments I've been involved in.